And your bond is revoked. It is doubled to $10,000. Plus, you must have a drug patch as a condition of bond, because the very first condition of bond is do not commit an offense. And illegal use of drugs, cocaine, is an offense. So you will be taken into custody. And Mr. Walker, that's you. Come on and get a resetting. You're free to go. You got it? Okay. You're free to go. He's in custody. Yeah. When you flunk the drug test, you're immediately taken into custody. I have Mario Hernandez.
Ready, Jeff?
Come on up.
Thank you.
2240195 is called Mario Hernandez. That's you?
Yes, sir.
Present. With Mr. Kelly, your attorney in the state's attorney. Yes. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
We do, Your Honor.
In summary, this indictment alleges that on or about March 10th, 2021 in Jefferson County, Texas, you committed the second-degree felony of indecency with a child. Do you understand what you're charged with here?
Yes, sir. If
convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached where you would be pleading guilty, prosecuted for the lesser included offense of okay. What is the offense?
Indecent assault. Class A.
What's the section number, please?
20.
I got 22, I guess. Indecent assault 22.012. A person commits an offense without the other person's consent with intent to arouse or gratify the sexual desire of any person. Person touches the breast of another person. This is a Class A misdemeanor.
Correct, Judge.
So, let's go back. So, the punishment range is not second-degree felony. It's Class A misdemeanor, right?
Judge, I'm sorry. I fill those out based on the allegation, the indictment, on what we're ultimately leading to.
Fingerprinting. Lofton. That one point. This last one in the box. You can have one more time. This guy got like.
Monday, right? So trying to resolve some of the remarks. All right. The things are have agreed to that you would be pleading guilty to lesser included Class A misdemeanor indecent assault. Which is found under Section 22.012 of the Texas Penal Code, which carries with it up to 1 year in the county jail and or up to $4,000 fine. Do you understand the punishment range?
Yes, sir.
The agreement is that you would be placed on deferred or unadjudicated probation for 2 years. Is that your understanding of the agreement?
Yes, sir.
Also fined $500.
Yes, sir.
If I follow that, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this Class A misdemeanor, lesser included offense under this indictment? Indecent assault, guilty or not guilty?
Guilty,
Are you pleading guilty voluntarily and because you are guilty?
yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document?
Yes, sir.
Understand it? Discuss it with your attorney? Or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
Objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
Is that true?
Yes.
State's Exhibit 1 is made a part of the record for all purposes. Printing's getting smaller.
Or later. I'm gonna do that. It's just-
Hmm. These don't have any, this doesn't have a reporting requirement, does it?
Only on,
Yes,
only on the second offense, Judge.
Okay. I think I understand all of this here. How old was the child? 10 years old?
Yes, sir.
So the only difference between this and the second degree felony of indecency with a child is the fact that y'all just dropped the age of the victim, right? As an element.
Yes, sir.
Everything else is the same.
Yes, sir.
Okay. All right. Anything else?
not from us. Judge.
Okay. It looks like sex offender registration is not required yet.
It's not mandatory. No, sir.
And it didn't get passed in this term, I guess.
No, sir. Not to my knowledge.
Because the statute says it's sexual offender registration is not required, and then it's in parentheses yet. So apparently, for whatever reason, they elected not to. The legislature elected not to change that other code. Well, anything else?
Not from us. Judge.
All right, and the defendant has entered his plea of guilty to this Class A misdemeanor. Is a pre-sentence report waived?
Yes.
Anything else to add? If not, I'm going to find Mr. Hernandez, you have pleaded guilty to this Class A misdemeanor, the lesser included offense of what is referred to as indecent assault. And under section 22.012 of the Texas Penal Code. You have pleaded guilty voluntarily. You are mentally competent to do so. You understand the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. However, I am going to follow this agreement, defer any finding of guilt, and place you on deferred or unadjudicated probation for 2 years. You are fined $500. There will be terms and conditions of probation, which are normal and customary for this type, a general type of offense, even though I wanted to go to sex offender classes and other things like that, that are normal and customary for other types of the offenses. And especially in light of the fact that the complainant was 10 years old at the time of this event. There will be other terms and conditions of probation which are normal and customary for this. Now, you're also going to do 180 days in the county jail. This is a crime of indecency. A 10-year-old child is victimized. You're going to pay a price for irreparable harm to a child on my watch. I just wish it was more. You took advantage of a 10-year-old more than once, according to the probable cause affidavit. And except for everybody just dropping the age, it's a second-degree felony. Plus mandatory reporting requirements for life, I believe. Otherwise. So what this court can do in managing the fair and appropriate remedy that I guess we can assess, although how do you take back the harm to a child? There is no way. You took advantage of a child. I have no sympathy for you. I have sympathy for the child. You took advantage of a 10-year-old child. Shame on you. You're going to jail immediately, 180 days, as a condition of this probation.
Your Honor.
Anything else?
Yes, Judge, if I may, considering that he's employed currently, will the court allow us to break that up in some way? I don't have something to proffer to the court right now, but I would at least like to ask the court to
Let me just say,
to consider.
Mr. Kelly is one of the most wonderful people I know. And he's a wonderful attorney, as well as just being a very fine, great man. He has children, and I know what he thinks. I know what we all think. You didn't give this child a chance to get ready for your assaultive behavior. And you did this more than once. And I have no sympathy for you. I'm not going to work on your terms in spite of the fact I would do almost anything for Mr. Kelly. This doesn't have anything to do with Mr. Kelly. He's trying his best to help you, but he cannot undo your terrible misdeed. It was an unnatural act you performed on a child. Shame on you. You're going to jail. The most I can put you is 180 days. And that's what you're getting. That's what we call justice under these circumstances. Unfortunately, we can't undo the assault that you performed on a 10-year-old child. Shame on you. Anything else? That's in all due respect. If it was any other kind of circumstances, Tom, but I feel sorry for that child. That is all. Thank you. Okay.
We're on the record, the matter of Jeffrey Pringle, 23-25, an appearance, counsel.
Good morning, Your Honor. Mr. Shemke, appearing on behalf of my client, this time we consent to the matter being heard via Zoom.
All right, thank you. And Mr. Pringle, your name, please. Please unmute, please unmute.
There you go. Sorry about that, Your Honor. My name is Jeffrey Richard Pringle.
All right, thank you. And today is the date scheduled for a probation violation. You are currently on probation for operating while visibly impaired. And this is alleging technical violation number 3, where it's alleged you tested positive for alcohol on October 2nd of this year. And counsel?
Your Honor, I had an opportunity to review the documentation. My client understands that he could have a hearing in which he could contest this violation. That will not be necessary, but I would like an opportunity to allocute on his behalf.
All right, sir, please raise your right hand. Do you solemnly swear or affirm the testimony about to give this matter to be the truth, the whole truth, and nothing but the truth?
I swear.
All right, thank you. And sir, you heard the allegation, correct?
I have.
As to the allegation you tested positive for alcohol October 2nd, how do you plead?
Guilty.
And you've gone over your advice of rights with your attorney, correct?
Correct.
And you understand all of those rights?
I do.
And you also understand by entering into plea, you'll be waiving some of those rights, specifically your right to a contested hearing.
Yes, Your Honor.
And you also understand the possible penalty as a result of your plea.
Yes.
And you also understand that the recommendation here is for you to continue and complete all terms of probation, pay a $50 probation violation fee, 60 days on the alcohol tether, and 15 days jail. Do you understand that?
Yes, Your Honor.
And you understand that I could follow that recommendation in its entirety or amend it or not follow it at all. Do you understand that?
Yes.
And knowing all that, do you still want to continue with your plea?
I do.
All right. And has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
They have not.
All right, counsel, if you can please refer to your client.
I'd like to direct your attention back to October 2nd, 2023. You took a test as a order from your probation. Is that correct?
That is correct.
And you're not contesting that the test reflected and indicated use of alcohol?
I am not contesting that.
Satisfied, Your Honor.
All right, the court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violation, indicate technical violation number 3. And counsel?
Your Honor, I saw the recommendation, no objection to the alcohol tether, but I would ask that the 15 days in jail be suspended. I'd ask that he be given one final opportunity to demonstrate full compliance. Obviously, he'll have a tether on. He'll be under strict monitoring. If there's any violations, they will become very apparent to probation immediately. In this circumstance, Judge, I believe the alcohol would be satisfactory admonishment. We respectfully request consideration for this leniency. Thank you, Your Honor.
Sir, what was it that you had to drink?
I believe it was a beer, and that was on September 30th.
And are you going to tell me that you were watching football when you were drinking the beer?
As fitting as that would be for how the prior testimonies have gone, this one was not. I had a moment of depression after I just been laid off work, and I unfortunately slipped up. My safety network of individuals that I reached out to, unfortunately, were not able to respond to me on that particular day. So I've had to make some changes since then.
So you've served jail twice.
That is correct.
While on probation.
Yes, Your Honor.
And so your support people weren't available. Did you look for a meeting to go to?
I contacted my AA person. I tried contacting my therapist as well as some family and friends on that particular day.
Okay, I hear what you're saying, but did you attend an AA meeting?
I did not on that day. I am currently working with my mental health counselor to find a different group to meet with. We're still working on that though.
And so are you still participating in the outpatient counseling?
I am.
And so, sir, how much did you have to drink? How many beers?
It was one tall beer, Your Honor.
Sir, let's be honest here, okay? Let's be honest, because at the end of the day, right, you tested positive. It was greater than 10,000 nanograms per milliliter. And this was 3 days after you consumed it. And so it's still showing up. So it was more than one tall beer. What else did you have to drink?
To the best of my recollection, it was only just the beer, Your Honor.
And are you still laid off, sir?
I currently am. I do believe provided all goes well, I should be reemployed within the next week or two.
And why were you laid off?
I was laid off as my position was no longer deemed necessary.
All right. Well, that's all I can understand. What's going on here? However, your client's on probation for operating while visibly impaired. He said multiple probation violations as why he was served jail time, and it seems to be an every couple month thing. April 26th, there was a violation hearing, and he sent the court sentenced him to 5 days jail and then alcohol tether upon release. And then 3 months later, probation violation again for consumption of alcohol, 30 days jail, Wayne County tether. I'm sorry, 10 days jail, 30 days Wayne County alcohol tether. And then now we are here again, 3 months later, and your client consumed alcohol again. So I can understand, sir, that it's something that you're working through, but at the end of the day, you're still violating this court's orders, even knowing what it's like when you're in jail.
Yes, Your Honor.
The court's going to order you to continue to complete all terms of probation, $50 probation violation fee. The court's going to order 15 days jail. I'm going to suspend 5. I'm going to serve 10.
I am going to respectfully request consideration for a report day.
Okay, and what is it that you're looking, what that you have in mind, counsel?
Sir, how much time would you need to get your affairs in order with the understanding that you'd be going into custody?
I believe I'd be ready to report today if necessary.
Then, Judge, I just asked that he be able to report by the end of today.
All right. All right, and then 60 days on the alcohol tether upon your release. And I will do a jail review on January 8th. At 10 a.m. All right, and sir, please email into Ms. Shine, she'll give you reporting instructions, okay?
I will do that, Your Honor. Thank you.
I think we're going to be off the record for a moment. Davis, 232-338. And appearance, counsel?
Good morning, Your Honor. Christopher Shemke appearing on behalf of my client. At this time, we consent to the matter being heard via Zoom.
I thank you, and sir, your name please for the record.
Your name, sir?
Brian Davis.
All right, thank you. And counsel, as to the arraignment.
We waive formal reading. My client stands mute.
Court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and we'll schedule this matter for a pretrial on November 14th at 10:15 a.m. And counsel, as to bond.
Your Honor, as to bond, my client indicates that he will appear at any and all future court dates and strictly comply with terms and conditions. On the positive, it's my understanding that he doesn't have any pending cases. He's 40 years old. He graduated high school in 2002 and has college credits through Baker. He's currently working full-time, 40 hours plus at DSC Painting in Lincoln Park. He does live by himself in E-Course. Well, he has roommates, but he has no relatives that reside with him. Judge, he in fact has worked today. Obviously, looking at the nature of the case, I'm assuming that if a plea were to potentially be effectuated, cost and fines would absolutely be part of the admonishment. That being said, with his employment, I would ask for consideration for a personal bond. He gives great assurances that he will appear at the next court date, and he's looking forward to getting this matter concluded. Thank you, Judge.
Okay, and so if you were to test today, what's in your system? Mr. Davis, what would be in your system if you were to test today?
Maybe the alcohol from last night and marijuana. That's the only medication that I take.
Do you have a medical marijuana card?
No. I'm a more holistic type of beliefs, and I haven't found it necessary to get a doctor's prescription for it since the state of Michigan. I don't like on my probation, I don't have to drop for it or anything.
And what are you on probation for, sir?
Like a 7-year-old DUI. It's coming to the end of it right now, but I'm still on probation for it. I've done everything except I still owe them a little bit.
Hold on, sir. Hold on, please. Is that from out of the Third Circuit Court?
Yes.
Okay, and that's from Lincoln Park. It originated at Lincoln Park?
Yes, ma'am.
Okay, well, that wasn't 7 years ago. It was 3 years ago.
No,
Sorry,
that's
4
when
years ago.
that was the conviction of the case. That's when I started my probation. It's been 7 years, ma'am. 6.5.
What I'm looking at is July 29th, 2019 is when you were arrested, and your judicial segment as to when you pled was April of 2022. Unless you have another one you're talking about. What's that, sir?
I don't believe that paperwork's fully correct. I'm not sure. With it not in front of me, it's hard for me to remember, Your Honor. I've been dealing with a lot of court cases. I thought I was coming to the end of it, but I apologize for my behavior last night.
So you don't live in Lincoln Park, you live in E-Course?
Yes, ma'am.
And you're on probation for operating while intoxicated. You're telling me that you're allowed to drink alcohol?
No, I'm not supposed to, but if I haven't drank alcohol. This is the first time I drank alcohol in a very long time, Your Honor. And I don't believe I was above, like, I don't want to get into specifics today, but I believe that, there's some discrepancies in the case. I'd rather talk to my lawyer about it in private.
Well, that's fine. That's your prerogative. You absolutely have that right, sir. The court's based upon your criminal history, the fact that you're currently on probation, and it's alleged that you were consuming alcohol. The court's going to, and that was a violation of your probation order as well. And to confirm you're going to be appearing, the court's going to order a $10,000, 10% bond. I'm sorry, $5,000, 10% bond.
Your Honor, would there be any consideration for a personal bond with a tether? My client indicates that he's not gotten paid yet, and I don't believe that he'll receive a paycheck until next week. If the concern is about his sobriety, he indicates that he will happily submit to random tests for drugs and alcohol, that he would wear a tether, and furthermore, he'd be inclined to do AA daily. Thank you for that consideration, Judge.
All right, and the court's hearing what you're indicating, counsel, but the court does have concern for the welfare of the public as well, given Mr. Davis's inability, it appears, to comply with court orders. And so the court will note that in the event Mr. Davis does postpone, that he is not to be released without an alcohol tether and not to possess and consume alcohol or drugs unless prescribed. All right, we'll see you on the 14th. We'll see you on the 14th. Thank you. Okay, and then this is the matter of the Blake Wellman 202060A. We're still on the record. And
Your Honor, my
counsel?
Wellman had texted me in the interim and wanted to have a breakout room. He had wanted to discuss something.
Okay, that's fine. And then what about Nicholas Brown? Is that ready to go?
I'm ready to go on, Mr. Brown. Unless Mr. Brown needs to discuss something, I'm ready to go on it. Mr. Brown, do you need to speak with me? So no, I need to speak with Mr. Wellman as well as Ms. Bond. I am in receipt now of the violation hearing. In the interim, I was able to contact probation. I have all the appropriate documents.
Okay, so let's handle Mr. Brown first. We're in this matter of Nicholas Brown 231485. And counsel, your appearance, please.
Good morning, Your Honor. Christopher Shemke appearing on behalf of my client. This time we consent to the matter being heard via Zoom.
All right, thank you. And Mr. Brown, your name, please.
Nicholas Marcel Brown.
Okay. And so today is the date scheduled for probation violation. Your client is on probation for operating while visibly impaired, and it's alleged he tested positive for alcohol October 22nd. And counsel?
Your Honor, as to the violation, my client is not requiring a violation probation hearing. He understands he can contest this violation. That will not be necessary.
All right, sir, please raise your right hand. Do you solemnly swear from the testimony you're about to give this matter to be the truth, the whole truth, nothing but the truth?
Yes.
All right. And you heard what your attorney indicated, correct?
Yes.
And as to the allegation that you tested positive for alcohol on October 22nd, how do you plead?
Guilty.
All right, and you understand that you understand your rights
Yes.
as it relates to probation violation, correct?
Yes.
And you understand by entering into a plea that you'll be waiving some of those rights, specifically your right to a contested hearing.
Yes.
And has anybody promised or anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
And you also understand the possible penalty as a result of your plea, correct?
Yes.
And you understand that this court can adopt that recommendation in full, in part, or deviate from it completely, correct?
Yes, ma'am.
You understand the recommendation is for you to continue and complete all terms of probation, pay a $50 probation violation fee, 30 days on the alcohol tether, outpatient counseling, and mandatory jail for any future violations.
Yes, ma'am.
And knowing all that, you still want to continue with your plea.
Yes, ma'am.
All right, counsel, you can please refer to your client.
Yes, I'd like to direct attention back to October 22nd, 2023. Did you test positive for alcohol?
Yes.
Satisfied, Your Honor.
All right, the court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violation and indicate technical violation number 1 and counsel as to the recommendation.
Your Honor, as to the recommendations, I ask that they be adopted. My client is aware that he is not to have any drugs or alcohol for the duration of his probationary period. He understands that he will be admonished today, and any further violation would most likely result in jail time. I feel compelled to indicate that he is sincere and contrite and would like to go forward with probation without any further instances. Thank you, Judge.
Okay. Sir, what was it that you had to drink and what were you doing? Watching football?
No, ma'am. I had took a couple of shots of tequila. It was my daughter's first birthday, and the moment that the event happened, I was served divorce papers. So I went into a deep depression, and the next morning I was able to wake up and call my spiritual counselor as well as my therapist.
Okay, I'm sorry, you said that on your daughter's first birthday,
I was served
that you
divorce
were
papers.
served divorce papers. Okay,
Yes,
was
ma'am.
it your daughter's first birthday party or it was just happened to be your daughter's first birthday?
No, it was her first birthday party. She just turned 1.
Okay, and during the party, you were served with your divorce papers?
Yes, ma'am. Like the moment that the party had ended, when we was wrapping up and cleaning up, that's when she had served me divorce papers.
She gave them to you directly or somebody else served you?
Somebody else had served me, like right then at the party, as we was leaving out.
And so after that is when you decided to consume a couple of shots of tequila?
Yes, just to help me cope with the pain and to help me sleep. Yes, ma'am. Because that was something that was unexpected and something that I would have never thought would have happened, especially since us having our first child together.
Okay, well, counsel, I'm sorry, anything else as to?
I would like to say this though, since our last meeting, I have been able to try to get my my warrant in Detroit taken care of, and I've also have received a promotion at my job that I'm at right now.
All right, and where are you at? Where are you working right now, sir?
Working at Amazon.
All right, well, congratulations to you on your promotion. All right, counsel, anything, I'm sorry, as to the recommendation?
Ask to be adopted.
All right. The court will adopt the recommendation. Sir, you're to continue to complete all terms of probation. You're to have a 30-day alcohol tolerance. You have that on today. What time do you get off work?
I get off work at 6 o'clock.
Okay, you're going to have to email into Ms. Shine as to how you go about getting that tether today. And you are to enroll and participate in outpatient counseling and mandatory jail, sir, for any future violation.
Understood.
And sir, tequila has not been your friend. You had tequila on your original offense date, right? Half a pint of it?
Yes, ma'am.
Maybe you should just not have it anywhere in your house.
That is all gone.
All right, email into Ms. Shine. She'll give you the information on how to get that tether today.
All right, thank you.
All right, thank you. Have a good day.
You as
All right,
well.
let's go off the record. All right, counsel, I'm going to make you a co-host in the matter of Erica Bond 23910A and appearance counsel.
Good morning, Your Honor. Christopher Shempke appearing on behalf of my client, sending to the matter being heard via Zoom.
All right, thank you. And Ms. Bond, your name please for the record.
Erica Bond.
All right, well, you were sentenced on June 6th. You're on probation for operating on visibly impaired. It's alleged that you failed to register for drug testing.
Yes, ma'am. I
And
have,
hold on, ma'am. And counsel as to this matter.
Your Honor, we will not be requesting a violation probation hearing.
All right, please raise your right hand. Do solemnly swear from the testimony you're about to give this matter be the truth, the whole truth, and nothing but the truth.
I do.
All right, and counsel, I'm sorry, and ma'am, as to the allegation, how do you plead?
This would be guilty because you're admitting that you failed, and I'll have an opportunity to speak on your behalf. So as to this question, how do you plead?
A guilty, ma'am.
All right. And you've gone over your rights and rights for probation violation purposes with your attorney, correct?
Yes.
And you understand all of those rights.
Yes.
You also understand by entering into a plea that you'll be waiving some of those rights, specifically your right to a contested hearing.
Yes, ma'am.
And you also understand the possible recommendation and the possible penalty, including the recommendation for you to continue and complete all terms of probation, pay a $50 probation violation fee, increased testing, 30 days on the alcohol tether, and mandatory jail for any future violations. You understand that?
I do.
You also understand that that this court could adopt that recommendation in full, in part, or not at all. Do you understand that?
I do.
I understand the court can also deviate from this recommendation.
Yes, Your Honor.
All right, and knowing all that, you want to continue with your plea.
Yes, Your Honor.
All right, counsel, if you can please party your client.
Yes, did you fail to register for drug testing as ordered by probation?
I did.
Satisfied, Your Honor.
All right, the court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violation, indicate technical violation number 1 based upon your plea of guilty. And counsel?
Judge, I'd ask for a deviation from the recommendation. It does seem a little bit aggressive. This is not a scenario where my client tested positive for drugs and alcohol. In fact, she is eager to provide a sample to the court to show that she is maintaining her sobriety. She found herself in a unique position where financially she was struggling. However, she is going to be in a position to get fully registered within the next 48 hours and then obviously comply with any terms and conditions. Judge, I'd ask at this point potentially that any sentencing be momentarily suspended to verify the results of my client's testing. At the most, Judge, I'd ask that potentially she has to pay the $50 fine for the inconvenience of having to come to court. But I do ask that sentencing be momentarily suspended to verify my client's sobriety. And if she is in fact clean, as she indicates, that this would be her first and only violation in her probation. Thank you, Judge.
Okay, so here's what's troubling is I'm not really sure, and I have to figure out why it took so long for this to come before the court. I have to double check that out because you've been on probation since June and you've gone 4 months without any testing.
Yes, I was just told to at the very end of October when I went to see Marcy. She let me know I would begin testing, that she did not tell me, and I was not aware of any testing. She wasn't aware I was supposed to be tested. It was not in my packet. So she just told me at the very end of October. My son has been suspended for the last 10 days. I have been at home with him. I just started a new job.
Hold on, please, hold on. So I will note that at the time you were sentenced, it was when one probation officer left and then Marcy began her position. So I will note that. However, you're telling this court that when you received your instructions, you didn't have anything regarding testing.
No, ma'am, I did not. And they did not tell me to, and they were not aware I was to drug test.
Ma'am, I don't believe that that's accurate. You are given that information twice.
I was not told to drug test until Marcy told me at the end of October.
Ma'am, you received information, you received written instructions, did you not?
Yes, there was nothing about, there was something that says I could be submitted to random drug testing, but there was nothing in writing that I was to. And I was not told about submitting until the end of October.
Ma'am, this court ordered you for random testing, okay? So the paperwork that you indicated or that you received that states you could be submitted to random testing, right? Is that what that says?
Yes, I could be, yes. And they did not tell me that I was to. I did not get one of the papers that they just gave me for the drug testing. I never received one of those. I just now got it, ma'am, and I'm just now getting new employment in order to pay my probation fees and these new fees that I'm incurring for the tests. I did lose my other job. My uncle passed away that I was working with. I've just
What's your new job?
the Dollar Tree on Fort Street in Emmons and Lincoln Park.
Okay. So here's what I'm going to do, ma'am. If you're tested right now, what's in your system?
Nothing but the prescriptions I am supposed to take.
And does probation have a copy of those prescriptions?
Actually, I have them in the car. I can go out and get them and bring them in for her.
Okay, that doesn't answer my question.
No, she doesn't. She doesn't, because I wasn't told that I was supposed to drug test. So why would I give her my prescriptions when I wasn't drug testing?
Okay, ma'am. You're going to go get those you're going to go get those prescriptions.
Sure.
You're going to give those over to probation right now, and you're going to go test today.
Okay, no problem.
And then we will set this for sentencing on November 13th at 10 a.m.
Thank you, Judge.
That is correct. 0910.
Okay, do that right now, please, ma'am, and then we'll see you back on Monday. So the court will order a $5,000 personal bond. We'll see you back on Monday. Stop over and see Marcy. Thank you. This is the matter of Blake Ballman, 202060A.
Good afternoon, Your Honor. Christopher Shemke, appearing with my clients. Time to extend to the matter being heard via Zoom.
And sir, your name, please.
Blake Wellman.
All right, and today is the date for a probation violation. Your client is currently on probation for disorderly conduct, and it's alleged that your client tested positive for alcohol on October 2nd of this year, which would be technical violation number 3.
Yes, Your Honor. As to the violation, my client will not be contesting that. He will admit responsibility, and we are not asking for a hearing.
Please raise your right hand. Do you solemnly swear or affirm the testimony about to give in this matter be the truth, the whole truth, or nothing but the truth?
Yes, Your Honor.
Okay. And sir, as to the allegation you tested positive for alcohol, how do you plead?
Guilty.
And you've gone over your advice of rights with your attorney, correct?
Yes, Your Honor.
And you understand all of those rights?
Yes, Your Honor.
You also understand by entering into a plea that you'll be waiving some of those rights, specifically your right to a contested hearing?
Yes, Your Honor.
And you understand the possible penalty as a result of your plea today, that would be the recommendation being for you to continue and complete all terms of probation, 5 days jail, increased testing, and probation violation fee.
Yes, Your Honor.
And you understand that this court could adopt that in full, in part, not at all, or deviate. Do you understand that?
Yes, Your Honor.
And knowing all that, you want to continue with your plea.
Yes.
Has anybody promised or anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
All right, and counsel, if you can please budget your client.
I'd like to take your attention back to October 2nd, 2023. Did you test positive for alcohol?
Yes, sir.
That's right, Your Honor.
Court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violation indicate based upon your plea of guilty, technical violation number 3. And counsel, that's the recommendation.
Your Honor, as to the increased testing, no objection. Judge, I saw that it's recommended 5 days in jail. I asked that be suspended in lieu of my client getting a tether for 30 days. Thank you, Judge.
Okay, let's see here. So your client was sentenced on March 17th of 2021. We had a bond, he was height eligible. We had a bond violation hearing April 27th of 2021. And then your client failed to appear for a probation violation on May 26th of 2021. A warrant was issued. Then it was set for probation revocation hearing on August 8th of 2022. Your client failed to appear. September 2nd of 2022, the warrant was issued. September 29th, the court rescheduled your probation violation as you had a different address and apparently didn't notify us or somehow went to the wrong address. So October 17th, the court of 2022, you had a probation violation hearing. You pled guilty, the court revoked HIDA. You had a probation revocation hearing. The court indicated 30 days tether, house arrest, reinstate probation for 18 months. Anger management class was to be registered within 21 days of proof shown, GED, mandatory jail for any future violation. January 30th of this year, there was a probation violation where you pled guilty and this court adopted the recommendation, and the court did not send you to jail, even though the court ordered mandatory jail for any violation. The court increased your testing and continued. That was because you failed to submit to a drug test on January 3rd. Now we have this matter where you tested positive for alcohol. What was it that you were drinking, sir?
That Sunday of, I think it was the 1st or the 29th, I went to my fiance's aunt's wedding and had a couple shots with them there and had a few beers, and then the next day Monday, my color got called, and I knew I wasn't supposed to be drinking, like at the time when I got put on probation, because I wasn't of age, but with my charge having nothing to do with alcohol or drugs, I didn't know that I couldn't drink, so I had a few drinks with them on their wedding day, and then.
No, sir, listen, you're talking on both sides of your mouth right now. You said you knew you weren't supposed to be drinking. And then you tried to justify it by saying that now you're of age, and because your offense didn't have anything to do with alcohol or drugs, that you thought that you could still drink. So it's one or the other. You thought you could or you couldn't.
Well, when I got put on probation, I wasn't 21 yet. When I first started this, back when I first got the charge, that's why I said that. But I didn't know I couldn't drink because of my charge was just being disorderly. I wasn't under the influence when I got the charge, and I'm not a drinker as is. I'm rarely ever drink unless it's an occasion like the wedding.
Well, sir, you weren't supposed to drink, and you knew you weren't supposed to drink. There wasn't any caveat in your instructions that said you're not allowed to drink until you turn 21.
I understand that, but I've been doing everything I can with this probation to make like to get it completed. I did my anger management. I enrolled into school this year. I'm doing online as of right now. I'm enrolled online schooling. I did my anger management. I paid all my fines. I'm trying to be on a straight and narrow path to get this out of the way. It was just a slip up. I apologize for it. And I
And
understand
you went to
whatever.
a wedding, I'm sorry, the day of the wedding was what day?
It was a Sunday. I think it was the first.
And you had 2 shots, or what's a couple to you?
Um, I don't know, maybe like 3 or 4 shots and then a couple beers too. There was an open bar there, so I had a couple shots with them, and then I just had a couple beers to myself. Well, it was all at the event.
All right, well, sir, this court ordered mandatory jail for any violation, and now you have a violation.
I understand. I was just trying to avoid it. I'm a single income household. It's just me, and I mean, my fiance don't work. She stays home with the kids. I do roofing, so I'm a seasonal worker, and it becoming close to the end of the season, we're slowing down. I really can't afford it, but I definitely understand if I have to because it's my own fault.
And what is your work schedule, sir?
Monday through Saturday, start at 7 a.m. and usually whenever the job's done is when I get off.
All right, well, sir, I'll give you until Friday to report so you can make some arrangements with your boss. Unless, do you have less work next week? I'll give you that accommodation.
I don't know the jobs. I already informed my boss that I might have to go do 5 days because when he sent me the paperwork. So if I have to report, I can report today and just get it out the way.
Is that what you'd rather do, or would you rather wait until Friday?
No, I'd rather just do it today, get it out the way. I already told him. He's already informed about it. My boss, he's okay with it. He's like, I'll still have a job and everything.
Okay, well, it's very commendable that you were upfront with your employer. All right, so the court will order 5 days jail. You're gonna continue to complete all terms of probation, increase testing upon your release, $50 probation violation fee, and sir, I'll indicate report today. So please email in Ms. Shaw and she'll give you those instructions, okay, sir?
Okay, thank you.
All right, thank you.
Bye.
Have a good day.
You too.
All right, anything? All right, thank you. All right, we're off the record.
Are there any other in custody, Judge?
I believe that there are 2 other in custody, but I don't think we have the paperwork back on those yet.
Okay,